And you're very welcome to this, the last in our webinar series on the theme of overcoming barriers for adult survivors of child sexual abuse. Today we're focusing on the child protection system, and I'm delighted to be joined by Dr. Joe Mooney. Joe is an assistant professor in social work in UCD. He has in the past been a practicing social worker in child protection, and his research interest again lies in the area of child protection. Joe is also a board member of One in Four. So Joe, you're very welcome.
Thanks very much, Maeve. Delighted to get the invite and delighted to be here. Thanks very much.
So Joe, just to begin, maybe your thoughts about the barriers that are there for adult survivors in accessing the child protection system, and why people might want to do that.
Yeah, it's a really, as with all of these issues surrounding sexual violence in general, it's a really complex issue, and it's a complex system. And I suppose Deirdre Kenny, your deputy CEO, mentioned in the last webinar that there are certain dynamics created by an experience of childhood sexual abuse. And while we can't treat victims and survivors as some sort of homogenous group, there are certain commonalities that the research would bring up and that are well recognized that are possible impacts of experiencing child sexual abuse. Issues around shame, stigma, issues around self-worth, belief, and maybe trust, and particularly in relation to authority figures or authority bodies. So there's a complexity there created by the instance of child sexual abuse itself. And when you bring that into contact then with a system that's complex, such as the child protection system, particularly in Ireland, a child protection system that, while robust in and of itself, wasn't designed with adult disclosures and adult engagement to begin with. We look at adult disclosures being recognised in the child protection system, in child protection policy, since 1999, but the legal underpinning of that child protection system is there since 1991. So it was never really designed with adults in mind engaging to make disclosures of childhood sexual abuse. That then added to the fact that I suppose the training of social workers is detailed and comprehensive. As a social work educator myself now, but it is a generic training. We equip social workers to deal with all facets of the profession, from mental health to adult social work to probation work to child protection work. So the coverage of training around dealing with disclosures and dealing with sexual abuse in general, while it's there, it's not to the level of detail that was required to deal with a comprehensive risk assessment of sexual abuse and to deal with the trauma that a person might be experiencing, having experienced sexual abuse in childhood. So there's those two elements that present as barriers. That then is compounded somewhat, I suppose, by an uncertain legal footing, as I mentioned, but a lack of clear policy and guidance around how social workers on the front line should engage with adults who have been impacted by childhood sexual abuse, and what needs to be done in terms of risk assessing the disclosure that they bring forward. Social work practice is improving in this area, I'd have to say, and we are building some specific teams in social work that receive these disclosures. And when you build a specific team, you develop expertise, and there's some excellent frontline workers in this area who know exactly what they're doing. But the system in general, which is one of the main findings of my own research, the system in general can act as a barrier for adults coming forward. That lack of legal underpinning, that maybe lack of an understanding of the dynamics of abuse, but also the dynamics of disclosure, and then that policy and training and frontline practice piece. So a complex system, but potentially interacting with lots of the acknowledged dynamics of childhood sexual abuse.
Okay, and Joe, your research focused on the experience of adults engaging with the child protection system. What sort of things were the adult survivors saying?
Yeah, so I suppose the research was interesting, and it's funnily enough, it was 2011, it was 10 years ago now that I came to One in Four actually, and yourself and Deirdre at that time explained that adults were engaging with the child protection system to make these types of retrospective disclosures, as they're called, and were receiving variable responses depending on which team they went, sometimes depending on which social worker they went to. So the original idea I had was, there's a policy gap here. We need some sort of piece of policy research to develop this area. But the more I read about it, the more I read about dynamics of abuse and how it can impact the individual, I felt I needed to go to the individuals themselves. And I think, strongly believe that any policies and practices in this area should be built from the survivors' experiences upwards. And they should be involved at all levels of that construction. So the research, as you mentioned, engaged with adults who've been through the child protection system to make retrospective disclosures. And the types of issues I suppose I found in talking to those adults was, in some instances, poor administration and a lack of information provided to the adult as to what happens when you make a retrospective disclosure. And that's really impacted by many things: that lack of legal underpinning that I mentioned, a lack of clear policy over the last number of years as to how social workers should manage this. But we also had that lack of expertise then was appreciated by the adults, that they felt that some of them went so far as to really remark on the social workers' really critical, important work in the community in protecting children and providing for child welfare and family support. But perhaps seeing this area of adult disclosures as not being the mainstay of social work practice, and really empathising with social workers that didn't seem to have the clear guidance on this. But at the same time, they were the ones getting the end result of this lack of clarity, maybe this lack of expertise. The adults, it was a narrative piece of research. So I posed one question and the adults spoke themselves, and they spoke at length for, on some instances, 40 to 50 minutes, non-interrupted and non-prompted. And they acknowledged the legal complexity in the area. They felt that this whole area of assessment should be on some sort of a statutory footing, which it's not. That's getting more attention now. And they also mentioned some interpersonal issues, and I don't like to single out individual experiences of an interaction with a social work professional, because in the main, social work practice is an empathetic and a compassionate profession. But they did have some interpersonal experiences of either being interviewed by social workers who are of the same gender as their abuser, and that not being understood, being interviewed in a physical environment that maybe represented some of the dynamics of where their abuse took place, and that not being understood. So as I said earlier on, maybe a lack of understanding of the dynamics of abuse, first of all, but the dynamics of disclosure also, and what that means for an adult coming forward. There was a huge issue around control and handing over a story. We know, and Deirdre mentioned the last webinar that you had, as well as your other speakers as well, and former too, that people tend not to come forward. Child abuse, it occurs in secrecy and in silence quite often, and in a huge dynamic of power. It's hard to break through that, even if you know that you need to break through that. So people tend to delay. They tend to delay into adulthood if they disclose at all. And I suppose there's a huge issue around handing over that story at that point, and the control, especially to a system where you now appreciate that maybe there's an uncertainty as to what to do with this, how to assess it, what time this is going to take. So control was an issue, delay was an issue. One of the adults used an analogy of a grenade, and he said making a disclosure to the child protection system was like pulling a pin on a grenade and then waiting. You didn't know when it was going to go off. And given the often intrafamilial dynamics of childhood sexual abuse, not knowing when a social worker was going to approach a family member, not knowing when a letter was going to be dropped out to your house, you may not have told your wife, you may not have told your husband. So those sort of pieces were maybe underappreciated at the time. Practice is developing, but we have a way to go yet.
Okay. I mean, Joe, you mentioned social work as a compassionate, empathic profession, and yet social workers are placed in the unenviable position, really, of investigating what is essentially a crime, and then going to some sort of a decision, adjudicating on whether this happened or not, and then obviously putting in train. And I suppose the new social work or the new child protection policy that's being introduced by TUSLA, it sort of underpins that role, almost like a role of a police officer. What are your thoughts on that, and in terms of the social work profession and the situation they're being placed in?
Yeah, so I suppose, and what we're talking about here is a reboot of a draft policy that was developed in 2014 originally, responding to allegations of child abuse and neglect was its original title, and now known as the Child Abuse Substantiation Procedure. So even in titles alone, and the name says a lot, we can see that it's quite a forensic, legalistic document, and I'll be fair in saying the majority of social workers, but in fact I would suggest all of the social work practitioners frontline that I've spoken to have issues, not particularly with the policy, but with this type of work and the complexity of it, and being put in a position as a service to make these adjudications, which they're not equipped to do from a training point of view necessarily. Some teams are and have received forensic interviewing training, but are also not equipped to do legally. So there's no support or backup from a legal perspective in terms of doing this work. But on the other side of that, there's possibly no legal right or legal grounds to be even engaging in these types of assessments. So these are all questions that need to be answered. But for the social work's perspective, doing these types of assessments, I suppose what I found in my original research interviewing social workers back in 2012 on this issue is that they found that this whole area was an ill fit with social work practice, that they were asked to make these almost forensic, legalistic assessments when what they wanted to do was to be able to hold that adult and to be able to sit with that adult and work through what was going on for them and provide the best supports in the community that were possible to meet that need. Whereas the adult now is almost purely a source of information in terms of the social work process. And there's a problem with that, because there's a duty of care, I would argue, in terms of adults coming forward, where you're aware that there's not a necessary vulnerability, but a potential vulnerability. And that vulnerability is not being directly addressed or cared for. And that doesn't fit well, and it doesn't sit well with social work practitioners. And I think, in fairness to TUSLA, they've kind of been landed with this this sort of role, and they're grappling with it through a plethora of judicial reviews going back to the late 90s, which have shaped this policy into what it is today, which is essentially a legalistic framework of risk assessment. It needs to be that from the judicial review point of view, but I still think there's room to meet the adult where they're at and to be somewhat trauma informed. And I think social workers would agree with that in the main, and I think they would welcome that, to be able to essentially engage in what is the basis of social work practice, of person-centeredness, of empowerment, and of voice, and respecting that. So yeah, I think it's quite a complex position for social work practitioners at the moment, and I really welcome the current consultation that's been launched by TUSLA. I'm hopeful. But there's a lot of work to do, and I think there are some strategies we can take.
Right, and yet, I mean, we know it from 1 in 4 that most children don't tell they're being abused at the time it happens, and therefore the testimony of adult survivors is really important in protecting this generation of children. So, and also most adults who come into contact with us don't want to meet a social worker because of all the various issues you've outlined there. Mm-hmm. So, I mean, going forward, Joe, what do you think would be, a way to take into account all the competing needs, the legal needs, the judicial reviews and so on, the work of social workers? Is there a way out of this to make the system more, I suppose, victim-centric, and at the same time to make sure that allegations are properly explored and investigated, and ultimately that children are safer?
Mm-hmm. Yeah, it's a really tricky one, and there are suggestions, I suppose, we can make, and there's no clear path through this. It's so complex, and it's interesting that you mentioned that we don't receive the disclosures we need in childhood. People tend to delay if they disclose it all, and it's into adulthood when we receive these. So there's a lot of research out there to suggest we should be expecting disclosure in adulthood, more so almost than childhood. And services, not just child protection services, but criminal justice services, mental health, medical services, should be prepared for this, should be prepared for adults who are impacted by childhood sexual abuse to make those disclosures. And what to do with that when it arrives. So it's not just a one service needs to be improved here. There's a whole of society piece that needs to be worked on here. And we need to remember that almost 80% of the adults who engage with child protection services are there via mandated reporting. Now, I'm a supporter of mandated reporting. I think it's a positive move. I think the research stacks up behind it to support it. But we have a somewhat unforeseen engagement here in Ireland, whereby our interpretations of GDPR, for example, are sort of interacting with that mandatory reporting law, whereby yourselves in a counselling and psychotherapy setting are obliged to hand over information to TUSLA, and there's an interpretation that information then needs to be handed directly to the person suspected of the alleged abuse, and that, anecdotally at least, we haven't the research to stack it up, but is putting people off maybe coming to supports at first instance. So that's something that needs to be tackled straight away. I think we need a clear legal underpinning for social workers in terms of being able to conduct these assessments. So social workers do need to be able to conduct child protection risk assessments, no matter where the information of that referral is coming from, whether it's coming from an adult disclosure, whether it's coming from a GP or a school teacher or a parent themselves. They need to have the legal underpinning to engage in that assessment process. So there's a review of the Childcare Act undergoing at the moment, or underway at the moment, and I feel it's really important that process takes this complexity into account. And I think there's a clear template under the EU Victims Directive, albeit drafted in the context of criminal justice proceedings. It's fundamentally a trauma-informed document. It's a victim-centric document, and I think there's some clear pieces that could be proactively adopted into child protection policy. Outside of that, then, I think we need a whole system approach, as I said earlier on. I think the Barnahouse model for children, whereby children come forward, they make one disclosure essentially, that may take place over a number of meetings, but one disclosure to one service, and they get their legal, they get their therapeutic, their medical, their social input in one spot. So I'm not saying we should have a one building sort of centre for adults coming forward, but a wraparound system of services, a suite of services, because currently rape crisis centres and services like your own at 1 and 4 are really meeting that therapeutic need of the criminal justice system and of the child protection system. And I think, that's underappreciated. So there's the general day-to-day of your work, but you're picking up slack essentially for these two major systems in terms of therapeutic need of the individuals coming through. So we need legal underpinning. We need fundamental trauma-informed practice across the system. And I think we need a wider societal discussion and conversation about sexual abuse that creates an environment essentially that facilitates, encourages and supports people to come forward.
Some people like Conor O'Mahony, the Special Rapporteur on Child Protection to the government, are of the view that perhaps this function maybe doesn't belong in TUSLA at all. What are your thoughts?
Yeah, I tend to agree with Conor, and it's great to see that Conor, in his role as Child Protection Rapporteur, he has had an interest before taking up that role, admittedly, but since taking up the role, I'm delighted to see he's taken a focus on retrospective disclosures and the legal aspects around those. Yeah, there's an argument that the whole job of it is not for child protection, and I would tend to agree with that. I think there is the child protection risk assessment aspect of it should retain with social workers, but for Conor's suggestion for an adult disclosure to maybe be processed, for example, by a vetting bureau type scenario, whereby the information would be shared through that central vetting bureau service, I think that's to be welcomed, and I think we should be examining that. I think, again, it brings into play that whole of system approach. If somebody goes to the guardian, makes the disclosure. There's a child protection aspect of that passes from the Gardaí to Child Protection Services, and then they can process from there, and that happens in the normal day-to-day. I don't think the entire piece needs to be processed by the child protection system, and I think that needs to change. So I would agree with Conor on that. I think there's an information handling piece, there's a criminal justice piece, because this is both simultaneously a crime and a child protection issue. And then there's that protecting current and future children piece, which comfortably sits within the expertise of the child protection system.
Okay, so Joe, we're coming to the end of our conversation. Is there anything last thing you'd like to say that maybe we haven't touched on?
Yeah, I suppose it is a complex area. I think there have been improvements even in my short time over the last 10 years looking at this area. There is attention, which is welcome. There are improvements. TUSLA are making efforts to shape the policy that is guiding them. But ultimately, I would hope to see this as an interim step. There needs to be a wider piece as to how we handle disclosures in a child protection context. I welcome the development of regional teams and expertise within the child protection system. I think fundamentally we need to remember that initial point, and Bernard Gloucester, the CEO of TUSLA, raised it last week when, unfortunately, again, on top of COVID, the child protection system has been hit by this cyber attack. So our thoughts are with frontline social workers working through this. But he mentioned social work as fundamentally being a relationship-based practice. And I think social workers want to get back to that, whether it be dealing with adults coming forward to disclose, whether it be dealing with adults in the context of being parents or guardians of children, or whether it be dealing with the children and services around them themselves. So I think there's hope. I think there's hopefully light at the end of the tunnel. I think ultimately we need to be conscious of those dynamics of childhood sexual abuse and how they impact the adult coming forward. We need to meet the adult where they're at. I think we need them to be the centre of the care and the planning around this. I think we need to appreciate and not underestimate the significance of the language that's used, of the reception that an adult gets, whether it be by letter or by interpersonal meeting with somebody, and the significance of this for the adults. One of the adults who I interviewed had a very simple statement of, it needs to be appreciated that the whole week leading up to an interview or a meeting with a social worker, you're going to be reliving this. You're going to be thinking about it. You're going to be thinking about what you're going to say. You're going to be thinking about how it's going to be responded to and what way are they going to react. You're going to be thinking about how many social workers are going to be in the room and what questions they're going to ask. And that consumes your whole week or your whole month ahead of that meeting. Those sort of dynamics need to be appreciated. Another adult, just to close maybe, spoke about the legitimization that he felt when he got a headed letter saying your interview will be on such and such a date, and it made his experiences real. He was able to hold that in his hand, and that's an almost common scenario that I've heard from other victims and survivors since conducting the research. So those sort of issues and those dynamics need to be appreciated, that there are impacts of childhood sexual abuse, the experiences itself, but there are also impacts of disclosure, responses to disclosure, previous experiences of disclosure, how disclosure is currently being handled and met, and that needs to be appreciated within the system.
Okay, well, Joe, listen, thank you very much for our conversation. We just have a few minutes left for questions from people who are with us. And here's Kerry, who's one of the 104 staff, who's actually been looking at the questions as they come in. So Kerry, what have you got?
Well, thanks so much for this discussion. Some of the questions that are coming in are in relation to the therapeutic process itself and the trust that's required and how mandatory reporting, how that would affect it. So, for instance, it's challenging for adult survivors to disclose in therapeutic sessions, as they know that this will result in a child protection and welfare report form if the abuser is still alive. It can cause significant challenges for the therapeutic process and trust. So I was hoping that one of you can maybe speak to that and discuss the impact that this has on kind of the outcome a survivor can expect within the therapeutic process.
Okay, maybe I'll start and then Joe can come in. I mean, at 1 in 4, we've been operating mandatory reporting now for not many years. And what we found is that when it is explained to a survivor who's coming into therapy, what is involved and why we're doing this, that it is about child protection, but it's also about empowerment. It's about breaking the secret that Joe mentioned. And it is about saying, this was not my fault, it's not my responsibility, I'm handing the responsibility over. So when it's framed in that context, it can actually be a very powerful and positive therapeutic experience for the person. Like, we rarely get people who refuse to engage with us because of mandatory reporting. And obviously the other thing I would say is that 1 in 4, our advocacy officers will support the person right through that process, and also we're working very hard in terms of trying to influence JUSLA to make that process more sensitive to an adult survivor's needs. So Joe, do you want to say something about that?
Yeah, no, I think it's a really difficult one. And it's a really great question. And I mean, we need to, again, appreciate that 80% of retrospective disclosures come via mandated reports. I don't think it's the system of mandated reporting itself that's an issue here. I think it's what's required of the adult afterwards. So I think, a lot of the research, my own research, but other international research would stack up that concern for another child is a huge driving force of disclosure for some adults coming forward. And we have that common experience where they maybe have children coming to the age at which they themselves experienced abuse, and they feel, I need to do something about this. So concern for children and child protection is at the heart of a lot of disclosure for adults coming forward. So it's not the mandated reporting, I think, that's the issue. It's what's required then of the adult after that point. And I think, we've had a lot in the media, and it's been hyped up to a certain extent when we get, and phrases such as stress testing and cross-examination. Again, social work practitioners, would say this is potentially never going to happen, that you're going to have an adult in the same room as their perpetrator being directly questioned, and that's acknowledged. The inclusion of something like that in a policy is enough to put somebody off, and that's these are difficult things to manage and difficult things to develop. But I think listening to the services like 1 in 4, the rape crisis centres, listening to adults themselves, and building a robust system that's from a victim-centric sort of perspective and has a trauma-informed base, will rule out any complexity around mandatory reporting.
Yeah, the other thing that's very important particularly for survivors to understand, is that a survivor is never obliged to engage with JUSLA. I mean, as a psychotherapist, I am obliged legally to pass on information if I have that information, but a survivor is under no obligation to meet a social worker, to be interviewed, anything like that. Some of our clients choose to do that for the reasons Joe has just outlined, but others don't. And that's really important that people understand that.
So it sounds like it's not just the requirements of the person who comes forward, but the way it's communicated as well in a therapeutic process, but also wider media and policy.
Yeah, and we do a lot of training around mandatory reporting with psychotherapists all around the country. And what we find is it's often the therapist's anxiety is the problem, not the client's. That if a therapist understands what is at stake, the dynamic that is there, that you can potentially be colluding with keeping a secret, a very unhealthy secret. Once the therapists are equipped and armed with the skills to actually manage explaining about mandatory reporting, then there are rarely any problems.
Yeah, and we see that in other professions as well. It's common in the research around mandatory reporting that professions worry about breaching that trust between professional and client. So that's common experience, and I think it's the training, as you say, and the communication and the development of the knowledge around it that really helps sort of see the bigger system and what this is feeding into and why this is important, I suppose.
Yeah. I think we've time for just one more question, Kerry. So,
Well, it's a fitting question. It's can you give a synopsis of the key factors that would predict a positive outcome for disclosures? So to sum it all up, what are the key takeaways that you would envision would be an ideal scenario for positive outcome when a disclosure is made?
There you go, Joe.
There you go. Good, Scott. Well, I suppose the experience of disclosure, I suppose it's important to say, is as individual as the individual themselves who are disclosing. So the positive outcomes of a disclosure really depends on the person. And as I said, we can't treat victims and survivors as an homogenous group that are all affected the same way and have the same outcomes. So meeting that person where they're at, and I think meeting that person as an individual is the key message. And I think if you do that, and if you're with that person genuinely and listening to them, the outcome is going to be positive in terms of that person will feel heard, that person will feel understood, that person will understand what the process is. And I think that element of meeting the person and understanding that they're not just a purveyor of information, they're not just providing elements that can lead to a risk assessment. They're handing over their narrative, their own story and their experiences. And I think appreciating that, it's a very simple thing, but is a hugely powerful thing in any system, not just child protection system.
Great. Well, I'm afraid that we've just run out of time. So Joe, just thank you so much for taking the time today. That's been a really, really informative conversation, I think. And to thank everybody who's participating. This is the last of our webinar series for this year. So I'd like to thank you all, many of you have attended all 4 webinars, and it's certainly something we'll be repeating in 2022. So to wish you a good afternoon and thank you again.
Just to remind everyone, the webinars will be up on our website. So if any colleagues weren't able to attend the live sessions, it's always accessible on our website. So
thank you, Kerry. I forgot to say that. Okay, thanks everybody. Bye.
Bye.